Welcome to episode 4 of the Succession podcast. An audio-video reviewer on the law on succession based on the book by Paras. This is a continuation of our discussion on Chapter 2. In the previous chapter, we talked about Section 1, Subsection 2. In this episode, we will be talking about Section 1, Subsection 3. Subsection 3 is all about forms of wills. Let's begin. In order to fully understand today's topic, we first discuss ordinary or notarial wills and holograph or holographic will. As discussed in the previous episodes, an ordinary or notarial will is that which requires an attestation clause and acknowledgement before a notary public, among others. On the other hand, in a holograph or holographic will, the most important feature is its being written entirely in the handwriting of the testator, from the date to the signature. For this kind of will, an attestation clause or an acknowledgement before a notary public is not needed. Article 804. Every will must be in writing and executed in a language or dialect known to the testator. We must remember that this article does not recognize oral wills. In the case of holographic wills, the handwriting of the person may be proved by any witness who believes it to be the handwriting of such person because he has seen the person write, or has seen writing purporting to be his upon which the witness has acted or been charged, and has, thus, acquired knowledge of the handwriting of such person. Handwriting experts are usually helpful, but they are not binding upon the courts. Neither is an expert testimony mandatory or indispensable to the examination or comparison of handwriting. Article 805. Every will, other than a holographic will, must be subscribed at the end thereof by the testator himself or by the testator's name written by some other person in his presence, and by his express direction, and attested and subscribed by 3 or more credible witnesses in the presence of the testator and of one another. The testator or the person requested by him to write his name and the instrumental witnesses of the will shall also sign, as aforesaid, each and every page thereof, except the last, on the left margin, and all the pages shall be numbered correlatively in letters placed on the upper part of each page. The attestation shall state the number of pages used upon which the will is written, and the fact that the testator signed the will and every page thereof, or caused some other person to write his name, under his express direction, in the presence of the instrumental witnesses, and that the latter witnessed and signed the will and all the pages thereof in the presence of the testator and of one another. If the attestation clause is in a language not known to the witnesses, it shall be interpreted to them. Article 805 provides for the requirements of a notarial or ordinary will. They are as follows. The will must be in writing. The will must be executed in a language or dialect known to the testator. The will must be subscribed at the end thereof by the testator himself or by the testator's name written by another person in his presence, and by his express direction. The will must be attested and subscribed by 3 or more credible witnesses in the presence of the testator and of one another. The testator or the person requested by him to write his name and the instrumental witnesses of the will shall sign each and every page thereof except the last, on the left margin. All pages shall be numbered correlatively in letters placed on the upper part of each page. The attestation shall provide the number of pages used, that the testator signed the will and every page thereof in the presence of the instrumental witnesses, and that the instrumental witnesses witnessed and signed the will and all the pages thereof in the presence of the testator and of one another. Article 806. Every will must be acknowledged before a notary public by the testator and the witnesses. The notary public shall not be required to retain a copy of the will, or file another with the office of the clerk of court. Here, it is understood to refer only to notarial or ordinary wills. This does not apply to holographic wills. The express requirement of this article is that the will is to be acknowledged and not merely subscribed and sworn to. The acknowledgement coerces the testator and the instrumental witnesses to declare before an officer of the law that they had executed and subscribed to the will as their own free act or deed. What is an acknowledgement? It is the act of one who has executed a deed in going before some competent officer or court and declaring it to be his act or deed. It involves an extra step undertaken whereby the senior actually declares to the notary that the executor of the document has attested to the notary that the same is his own free act and deed. Differentiated from a jurat, which is simply the part of an affidavit whereby the notary certifies that before him, the document was subscribed and sworn by the executor. Article 807. If the testator be deaf, or a deaf-mute, he must personally read the will, if able to do so. Otherwise, he shall designate 2 persons to read it and communicate to him, in some practicable manner, the contents thereof. If the testator cannot read the will, or if he is illiterate, 2 persons must communicate its contents to him. The 2 persons designated need not be the attesting witnesses. Article 808. If the testator is blind, the will shall be read to him twice, once, by one of the subscribing witnesses, and again, by the notary public before whom the will is acknowledged. The previous article discussed the case for deafs and deaf-mutes. This article lays out the rule for blind testators. In here, there must occur 2 readings. The first reading is done by one of the subscribing witnesses. The second reading must be done by the notary public. It must be noted that the notary public before whom the will is acknowledged cannot be one of the 3 witnesses to the said will. Article 809. In the absence of bad faith, forgery, or fraud, or undue and improper pressure and influence, defects and imperfections in the form of attestation or in the language used therein shall not render the will invalid if it is proved that the will was in fact executed and attested in substantial compliance with all the requirements. This article provides the rule for substantial compliance. That is, as long as the purpose sought by the attestation clause is obtained, the same should be considered valid. Note that this does not speak of defects of substance but only of defects and imperfections in the form of attestation or in the language used therein. Article 810. A person may execute a holographic will which must be entirely written, dated, and signed by the hand of the testator himself. It is subject to no other form, and may be made in or out of the Philippines, and need not be witnessed. The previous articles discussed ordinary or notarial wills. This article and the succeeding ones talk about holographic wills. Why make a holographic will? For one, they are easier to make. To add to that, they are easier to revise and easier to keep secret. For these reasons, they are also easier to forge by expert falsifiers and easier to misunderstand. There is also no guarantee that there was no fraud, force, intimidation, or undue influence. There is also no guarantee regarding the testator's soundness of mind. The following are the formalities of a holographic will. The language must be known to the testator. The will must be entirely written in the hand of the testator himself. The will must be dated. The will must be signed by the testator himself. There must be animus testandi. It must be executed at the time that holographic wills are allowed. Article 811. In the probate of a holographic will, it shall be necessary that at least one witness who knows the handwriting and signature of the testator explicitly declare that the will and the signature are in the handwriting of the testator. If the will is contested, at least 3 of such witnesses shall be required. in the absence of any competent witness referred to in the preceding paragraph, and if the court deem it necessary, expert testimony may be referred to. Probate means the allowance of a will by the court after its due execution has been proven. It may be uncontested or contested. If it is uncontested, at least one identifying witness is required to avoid the possibility of fraud. If no witness is available, experts may be resorted to. On the other hand, if it is contested, at least 3 such identifying witnesses should be required. If a holographic will is lost or destroyed without intent to revoked and no other copy is available, it can never be probated because the best and only evidence for it is the handwriting of the testator in the said will. Article 812. In holographic wills, the dispositions of the testator written below his signature must be dated and signed by him in order to make them valid as testamentary dispositions. A testator may draft one part of a holographic will at one time and another part at another time. It may even happen that the latter dispositions are made even after the signature has been written. This is why Article 812 is necessary. It must be remembered that dispositions after the signature must be both dated and signed by the testator to be valid. Article 813. When a number of dispositions appearing in a holographic will are signed without being dated, and the last disposition has a signature and date, such date validates the dispositions preceding it, whatever be the time of prior dispositions. This article provides for the rules in curing the defects in a holographic will. Let's say the last disposition is signed and dated. The preceding dispositions which are signed but not dated are validated. Meanwhile, preceding dispositions which are not signed but dated are void. Preceding dispositions which are not signed and not dated are also void unless written on the same date and occasion as the latter disposition. Article 814. In case of any insertion, cancellation, erasure, or alteration in a holographic will, the testator must authenticate the same by his full signature. Here, full signature means the full or usual or customary signature. However, if both the first and second names are merely in initials, it is believed that this would be contrary to the intent of the law. Article 815. When a Filipino is in a foreign country, he is authorized to make a will in any of the forms established by the law of the country in which he may be. Such will may be probated in the Philippines. This article provides for the formalities of wills executed by Filipinos abroad. To illustrate, a Filipino in Germany can make a will there in accordance with the forms of Germany or of the Philippines. Article 816. The will of an alien who is abroad produces effect in the Philippines if made with the formalities prescribed by the law of the place in which he resides, or according to the formalities observed in his country, or in conformity with those which this code prescribes. This article provides for the formalities for wills executed by aliens abroad. An alien abroad may make a will in accordance with the formalities prescribed by the law of the place of his residence or domicile, his own country or nationality, the Philippines, or the law of the place of execution. Article 817. A will made in the Philippines by a citizen or subject of another country, which is executed in accordance with the law of the country of which he is a citizen or subject, and which might be proved and allowed by the law of his own country, shall have the same effect as if executed according to the laws of the Philippines. The previous article refers to aliens abroad. The present article provides for the formalities of wills executed by aliens in the Philippines. To illustrate, a will executed in Manila by a citizen of Spain living in Manila, and which follows the requirements in Spain, can be admitted to probate in the Philippines. Article 818. Two or more persons cannot make a will jointly, or in the same instrument either for their reciprocal benefit or for the benefit of a third person. This article discusses joint wills. They are those which contain in one instrument the will of two or more persons jointly signed by them. They are void in the Philippines. Joint wills must be differentiated from reciprocal or mutual wills. Reciprocal or mutual wills are those that provide that the survivor of the testators will succeed to all or some of the properties of the decedent. They are valid in this jurisdiction. However, if reciprocal or mutual wills are made in one instrument by two or more persons, they are void. Article 819. Wills prohibited by the preceding article executed by Filipinos in a foreign country shall not be valid in the Philippines, even though authorized by the laws of the country where they may have been executed. The prohibition applies only to Filipinos, so if a joint will is made by foreigners abroad and valid in accordance with Article 816, the same should be considered as valid here. We have reached the end of this episode. See you all on the next episode where we continue with the discussion. Please like, comment, and subscribe for more.